Good morning, everyone. It's Annie from AK Luxury Properties, and today I have real estate attorney Bryn Deb joining me to help answer some questions that I've been getting in regards to the evictions moratorium, especially because an extension was recently ordered. Hi, Bryn. Thank you so much for joining me today to chat about the moratorium on evictions. Can you start by telling us a little bit about your background and what you specialize in?
Yeah, hi Annie. Thank you so much for having me today. So my firm is A2B Legal, and we focus on real estate law, anything from evictions to purchase and sale disputes, contract review and enforcement. I work privately as well in-house for real estate brokerages, and I've been practicing about 14 years, and I'm also a licensed real estate broker.
Amazing. And we are so lucky to have you here today. And I mean, thanks again for joining us. I know first off, everyone's question is going to be, who does this affect and why should I care? Like, how does it affect me?
Well, we're here to talk about the eviction laws and the moratorium, and it's really having an effect on everyone,
Mm-hmm.
especially landlords and tenants, but investors and their property decisions, as well as other real estate professionals.
Right. So pretty much everyone who's involved in like the entire realm of real estate.
Definitely.
Mm-hmm. So let's dive into some of the key points that we should be considering and whether there are any differences in how it's handled at the local level, like LAOC versus California state level and versus federal.
So the laws are really complicated and they really keep changing.
Mm-hmm.
They're really making it very difficult for a landlord to terminate a tenancy.
Mm-hmm.
So let me just talk about the history a little bit. Let's talk about simpler times when terminating a tenancy wasn't so complicated.
Mm-hmm.
I'm talking about 2 years ago when
Yeah.
you could give somebody a 60-day notice if they were a month-to-month tenant for a reason or no reason at all.
Mm-hmm.
So long as it wasn't an illegal reason, there was no issues with doing that.
Right.
But starting in January of 2020, we have this statewide rent cap and just cause eviction law that came into place.
Mm-hmm.
And that's what we call AB 1482 or the Tenant Protection Act.
Mm-hmm.
So, what that did was really extend statewide rent cap and just cause eviction. And a lot of people are familiar with, LA County, and they already have rent stabilization ordinance or the RSO, which prevents them from evicting tenants who fall under the RSO without cause.
Mm-hmm.
So basically, the Tenant Protection Act created a similar ordinance for all of California.
Got it.
And, now as a result of 1482, you have to have a reason to evict. And there's about 15 reasons that really fall into play. So under 1482, there are some properties that were exempt, such as single family, condos, and new construction. But then in September of last year, we have AB 3088 that comes into play. And that's really in response to COVID-19. And that extended the just cause requirements for eviction to every property. So including single family condos, new construction. So there are no longer exemptions to the just cause. And then most recently, at the end of January, we have SB 91, which extended the same just cause provisions through June of this year.
Mm-hmm.
And on top of that, we have federal rent moratoriums, which is known as the CDC order.
Mm-hmm.
And then we still have local moratoriums with their own local just cause eviction rules, such as LA County.
Right.
So I can break that down. That's kind of the summary. Let's dive into it a little bit deeper.
Mm-hmm.
So again, just cause provisions apply statewide. And really under 1482, one of the first requirements was that a tenant had occupied the property for 12 months or more in order for these rules to even apply. Under the current moratorium SB 91, that no longer matters. It applies to all properties, whether you live there for 2 months or you live there for 2 years. And essentially there's two types of just cause. So we have at fault and no fault. And if we're talking about at fault, the most common is non-payment of rent, which we'll discuss in detail a little bit more. Breach of the lease, if you're causing a nuisance, using the property illegally, causing criminal activity, or not allowing the landlord access. Another one that they've recently put in this new moratorium is at the end of a fixed term lease, the landlord can offer the tenant a new lease with similar terms and conditions. And if the tenant refuses to sign that lease, they're saying that can also be a cause, an at fault cause for eviction, excuse me. So
it has to be like similar terms. It can't be like substantially different.
Correct. They can't take away services. They can't, it needs to be very similar. They don't want to give any reason for the tenant to say
so
that.
Like if they increased rent, even that would be too.
So they can increase rent. You do have to be careful with that because there are rent caps that fall under 1482. And so it's based on your local jurisdiction, and we're limited on how much you can increase rent. So it's generally 5% plus whatever the local jurisdiction CPI rating is. So you have to look all that up. So right now it's about, around 1%, roughly, give or take. So we're really talking about a 6% rent increase anyway. And if your tenant's not paying, you definitely don't want to increase the rent because that can be seen as retaliatory. But and again, I always say, if you have a good tenant and they're paying on time and they're not really bothering you, then maybe that 6% isn't worth it.
Right. Yeah, because it's definitely harder to go out and like screen new applicants, find a new tenant, and then you have to, make sure that they'll be good ones that'll take care of your property and pay rent on time.
Exactly. You never know what you're going to get. So if you have somebody good, I think they're very valuable. If they don't bug you for every repair, then you should try to keep them in there. And the 6%, maybe you don't go for it, especially right now in these tough times.
That makes sense.
So then we have our no fault reasons. So they've specifically limited these to these 5 reasons. We have owner occupancy. If the owner or a family member wants to move into the property, they're allowing them to give notice for that. If they want to take the property off the rental market completely, if the property requires a substantial remodel, and this has to be only because it's uninhabitable. It's very specific. If there's a government order to comply with or to vacate, or if the seller is in contract to sell the property. But in that situation, the buyer has to occupy. So this would not fall under arrangements for investors who are buying the property, to flip or to sell to somebody else. So they actually have to stay there and occupy it in order for it to fall under the no fault provisions. And then again, under the new laws, if we're talking about one of these no fault reasons, for reasons 1 through 4, the landlord is also required to pay that tenant relocation assistance, which is equal to 1 month's rent. So they can either have them waive that last month or have them pay it and pay that last month's rent. But if they are one of the exempt properties under 1482, which is single family home, condos, new construction, then they don't have to pay that relocation assistance. Okay. So let's talk about, the non-payment, because that's really what's happening these days. That's really the most common
big issue that everyone is, both landlords and tenants.
So when AB 3088 came into play, everyone was anticipating this big January 31st, 2021 date, because under AB 3088, a landlord was required to give a 15-day notice if somebody fell behind on their rent, as opposed to a 3-day notice,
Right.
which was how we dealt with it before 3088. And not only that, but attached to the 15-day notice, the landlord has to give the tenant a blank declaration where the tenant has a chance to say, hey, I can't pay my rent because of one of these COVID-related financial reasons. And they just have to sign it. They don't have to say what reason, and they return it. And at that point, the landlord is prevented from moving forward with eviction. And under 3088, the tenant was required to pay 25% of any rent that became due from September 1st through January 31st. And they had to pay that on or before January 31st. So if they didn't pay by January 31st, then starting February 1st, the landlord can move forward with an eviction for non-payment. So that's why that January 31st date everyone was anticipating. Well, what happened is at the end of January, Governor Newsom extended that deadline under SB 91 to June 30th. So now a landlord has a right to demand 25% of the rent from September through June, and that doesn't need to be paid until June 30th. So they could pay it monthly, or they could just wait and pay the whole amount on June 30th. And the landlord would not be able to start any eviction process until July 1st.
But just the 25% is required.
Only the 25% is required to be paid.
So then from all of this, it's really tenants that are benefiting from the moratorium, but only until June 30th. What happens at June 30th? So they only need to pay 25%. What about the rest of it? Is it just tough luck on the landlords, or?
No, so it doesn't go away. They're still going to owe the remaining amount, but it's actually going to become a personal debt of the tenant, and the landlord's going to have to proceed to recover those past due rents through a small claims action.
I see. So same thing for if they can't pay even the 25% by that date, then it would have to just go through small claims as well.
If they can't pay the 25% by that date, then the landlord can proceed with an unlawful detainer.
But then
Correct.
They still, I mean, that debt is still owed to them.
Correct. Yes, the debt is still owed. So whatever amounts they can obtain through the unlawful detainer, and anything beyond that, they could go through the small claims.
Got it.
But they're not allowing any small claims to be filed until till August. And I can imagine there's going to be an influx of filings at that time.
Yes. I can definitely see that happening. So this eviction moratorium definitely is detrimentally affecting landlords and possibly investors that are thinking of buying properties for rent. Because I know that a lot of potential investors and clients, they're sort of rethinking investing in properties now, or my landlords are saying like, hey, maybe I don't even want to lease the properties out now because they're just worried that people are going to say, they're going to, sign up, get in there, and then be like, oh, COVID, I can't pay.
Definitely. I mean, it's a real concern. Even, I have a couple of rental properties myself, and fortunately, we haven't had any issues with payment. But the new law has an additional requirement on landlords. So they're actually supposed to give a notice to the tenant, and that needs to be done by February 28th, informing them of this new law and the extension, and also the rental assistance programs that they can apply for. And if they don't give them that notice, then they would be precluded from moving forward with an eviction. So even if you have a paying tenant, if you're going to provide them this notice, that might cause them to think twice about making that next payment of rent. But it is required whether they're paying or not paying. That needs to be done. And I have provided a link to the form. The California Apartment Association is providing this form for free. So you can go to this link, you can
Mhm.
download the form, fill it
We'll
out,
paste
and
the
then
links
mail
in
it
the
to your,
captions.
yes, perfect. Yeah, mail it out to your tenant and have track, keep track of what that you sent it. So if that comes into question down the line, you have some sort of proof, keep a record of some sort.
Mhm. So then to recap, any sort of like recourse for the landlords would be just they have to wait until July 1st at the earliest.
Correct. Unless that's for non-payment cases. Then if you fall with one of those other reasons that we went through, the at fault or no fault, you could do that prior to July 1st.
Got it. That makes sense. So, Bryn, what about those who are specifically taking advantage of the current environment and holding off on paying rent? They're eventually going to have to pay it back, correct?
Yeah, so this is definitely another concern as well, because the law simply requires the declaration to be completed, and it is under penalty of perjury, but the landlord isn't allowed to request any sort of documentation. They can't ask for a W-2 or proof of unemployment or anything to show that they really are impacted by COVID-19. And what the declaration really says is it says, I can't pay my rent, and just because you have a loss of income doesn't necessarily mean you can't pay your rent. I have, for an example, I have a good friend and she's a teacher at an after school program. And, in a lot of areas, there's been no school for a year. So there's been no after school program. So that household is experiencing a loss of income. But her spouse, is still able to work. And fortunately, the salary that he earns is enough so they can continue paying their rent. So technically, they would not qualify to sign the declaration under penalty of perjury, but those declarations have attempted to be challenged in court, and they're not really going anywhere. It's not open to discussion. Judges aren't hearing, unless you're dealing with a high income tenant, there's a little bit you can do. But if we're talking about a high income tenant, which one of the minimum requirements is that they make 100,000, and again, it's a household makes 100,000. Even then, you can only use what documentation you currently have in your possession. So, when they applied in their application, if they provided any bank statements or proof of income, things like that, you cannot go out and seek additional information to use against them.
But even then, they can just be like, well, that was what it was when I applied. And now with the current situation, I just can't pay.
Exactly. So if they complete the declaration, the landlord really doesn't have a lot of options. They're kind of they kind of have to deal with it, unfortunately.
Until July 1st, unless it's extended, right?
Correct.
Got it. Well, is there any recourse or reassurance for landlords and property owners and investors, whether short-term or long-term?
Well, my suggestion to avoid this grueling process of eviction that we have right now would be to see if your tenant would agree to a repayment plan or repayment agreement where, not everyone's going to be able to do this because obviously if you can't pay your regular rent, how are you going to pay your regular rent plus something towards your arrears? But certain situations, if you're able to accomplish this would be my suggestion. Another thing would be, a lot of landlords just want the property back so they can get another qualified tenant to actually move in there and pay. So you could talk about, I'm going to waive so many months of rent, or I'm going to waive all of the rent if you just give me the property back. Because even if you do have the ability to try to collect rent from a tenant later, who knows if you'll ever receive a dollar. You get a piece of paper that says you're entitled to this amount.
Like even if they went through small claims and got a judgment, it's not necessarily that they would be able to collect on it.
Exactly. It can be very difficult. So if you can get your property back, quickly, it's kind of like a cash for keys arrangement, but you're not actually going to offer the tenant any monetary amount, but you're going to give them relief on the obligation to pay
Mm-hmm.
back rent, whether it's a full waiver or a partial waiver.
Mm-hmm.
And then another option that's come into play with this new SB 91 is a state rental assistance program.
Mm-hmm.
And this is what that notice that you're required to give by the end of February is informing the tenants about. And it's basically a federal program. And California was allotted about $2.5 billion to assist with these past due rent amounts. But unfortunately, the money is going to be distributed on priority,
Mm-hmm.
fortunately and unfortunately for certain areas. And so the first round is really going to be eligible households whose income is 50% of the area median income. And then the next will be those communities that were directly impacted substantially by COVID. And then the last round will be, eligible households whose income is 80% of the area median income. And this is supposed to assist with rental arrears from April 1st of 2020 through March 31st of 2021.
Yeah.
But in addition to all of that, the landlord really has to cooperate with this program. And so the program will pay 80% of the total arrears that were owed from that time, so long as the landlord agrees to forgive 20%.
Mm-hmm.
And then you can actually go to this website. They're going to start accepting applications on March 15th of this year. And if you go to housingiskey.com, you
Mm-hmm.
can get a lot more information on these programs. And I imagine, again, there's going to be an influx of applications starting March 15th.
Definitely. Well, last question, I think, is how long will this go on for? There seems to be various states, depending on the county, state, and federal levels. Which one would apply to where you are?
Sure.
I think the local one, right, like kind of takes precedence.
Well, so again, SB 91 is just cause eviction that applies in California as a statewide order. And that's, currently that's set to end June 30th. In addition to that, we have local moratorium with their own local just cause eviction rules, such as Los Angeles County. And Los Angeles County says, you know what, we don't really care what the state rule says. We're not going to allow just cause reasons to evict. We're not going to allow any no fault evictions in LA County. And so they specifically have prohibited evictions for non-payment of rent due to COVID for no fault reasons, including a substantial remodel, if you have a nuisance or you denied entry to a landlord, unauthorized occupants. All of those reasons are not going to qualify to allow you to move forward with an eviction.
Wow.
Yeah, and then on top of that, we still have our federal rent moratorium, which is the CDC order. And so this came into effect in September of last year. And basically what happened is a tenant completed this CDC declaration, then a landlord was prevented from removing the tenants from the property. And as this law came into effect, it really started to, they started to explain it further, and really it comes into play when they're physically trying to remove the tenant from the property. It's not supposed to affect the process of the unlawful detainer or the eviction process, but unfortunately there are some judges who are receiving these CDC declarations and halting the process. So while it's only supposed to postpone the actual lockout, that will depend on the jurisdiction and how the judge accepts the declaration. But it's only effective, it's set to expire March 31st. So what I've seen is a lot of landlords are making arrangements with the court, which allows them a judgment for possession, but no lockout prior to March 31st.
Wow, that's a lot of info. Well, thank you so much for all of this info. I did have some of the questions from AK Luxury Properties friends and clients. I think you've addressed all of them, but let's recap some of the top ones. Okay, so these were the top questions that we got. Of course, the first one, people wanted to know if it has officially been extended and until when. And I think you had said it was June 30th.
Yes, officially under SB 91, it's been extended to June 30th.
Got it. And then are they still allowed to pay only 25% of what is owed monthly? And you said
correct, so long as they complete the declaration.
Mm-hmm. And then you can pay it either monthly or all before June 30th. Correct.
Correct. You can pay, yeah, you can pay all of it, you know, you can pay some of it, or you have to pay all of it, the 25% on or before June 30th.
Mm-hmm.
Otherwise, your landlord can move forward with the
eviction.
eviction process.
Mm-hmm. When will the full balance of all months not paid be due? And what if I can't pay it when it is due?
So the landlords are actually going to be required to seek the remaining balance through the small claim.
Mm-hmm.
And this is, this gets a little bit more complicated because there's several notices that had to be given prior in order for the landlord to continue to be able to collect those rents.
Mm-hmm.
Okay, so I don't know if we really want to get into that.
Okay, well, are there any online sites where they can read more in depth about that if they wanted to know more?
Yeah, absolutely. I mean, CAR is obviously a huge one, but not everyone has access to that. I'd have to look one up, and I could probably give you that at a later time.
Or you guys can call me or Bryn and we can help you answer any specific questions you might have.
Yeah, that would be better. Let's try that again.
Awesome. Well, Bryn, thank you so much for joining us today and sharing all of this wonderful, albeit kind of confusing information on the evictions moratorium. I'm sure a lot of people had a lot of their questions answered and clarified. So we really appreciate that. And again, if anyone has any further questions on this topic or wants to set up an appointment to discuss what works best for your unique situation, please feel free to reach out to either Bryn or myself, and we will help you to get access to all the info you need to make informed decisions. So thank you for joining us today, and we really appreciate having you.
Thank you so much, Annie. I really appreciate being here. Yes, feel free to reach out to me or any other attorneys if you need further clarification, because the law is fairly complicated and again, ever so changing. So try to stay up to date as best you can before you want to proceed with any notices, because there is a lot of procedures in place that will penalize landlords for failing to follow procedure.
Yes, definitely consult with your local professional who knows about the laws in your specific jurisdiction.
Yes.
Alrighty, thank you.
Thanks.
Bye.
Bye.
Okay, here is Bryn's contact information and mine as well in case you have more questions. Thanks.